Major breaking news out of New York City. The United States Court of Appeals for the Second Circuit in New York City has come out with a major 260 some odd page opinion dealing with the 4 cases that were challenging New York's new anti-gun laws. Specifically, their issues by trying to make the entire state a quote-unquote sensitive place, which is a government-mandated gun-free zone, and expanding the licensing requirements before people can carry under the shall-issue regime. The good news is that the Second Circuit has knocked out some major efforts by the anti-gunners, and given that this is an absolutely terrible panel, that is very good news. But the panel made a lot of terrible mistakes that's not going to stand the test of time. We're going to break it all down when we get back. We have a lot to talk about, 260 pages long, and yes, I've read it. Hey folks, I'm Mark Smith, host of the 4 Box of Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and a 2-time Gundy Award nominee this year for top male influencer in the Second Amendment space and for one of the top voices in the Second Amendment space. I'm proud and honored to have received these nominations from the Gundy Awards for 2024. All right, major breaking news out of New York City. This is the Anton Young case. There's actually 4 cases together. Specifically, there were 4 cases that were argued back in March. These 4 cases were heard and decided together by a 3-judge panel, of Judge Jacobs, Judge Lynch, and Judge Lee. You don't need to know much about them other than one is an Obama appointee, one is a Biden appointee, and one is a Bush appointee. So basically, this is a terrible anti-gun panel. The Bush appointee, Judge Dennis Jacobs, is a law and order conservative, an urbanite. So I'm not surprised that he would not necessarily nail all these issues correctly. But obviously, this was a terrible panel. With that context in mind, I'm going to give you some very good news, which is that major parts of New York's anti-gun laws that were enacted after NYSERPA versus Bruin, just as a reminder, after NYSERPA versus Bruin was decided in June of 2022, New York State threw a hissy fit, and Kathy Hochul got up there and saying that we need to go back to muskets. So anyway, she then called an extraordinary session and passed a bunch of anti-gun laws. There were a series of lawsuits brought, 4 or 5 lawsuits in various courts in the Northern District of New York and the Western District of New York. Many of these laws were declared unconstitutional on a preliminary injunction basis. There was emergency appeals taken by the state of New York to the Second Circuit Court of Appeals on an emergency basis, trying to stay, which means to pause these injunctions. And to make a long story short, this case was argued in March. It's now been decided, 260 some odd pages by the Second Circuit Court of Appeals. I will put the links down below so you can check it out yourself. So the bottom line is, let me give you the good news, and then we're going to give you sort of the bad news, which is really not that bad in the grand scheme of things because there's terrible mistakes that this panel made, and none of this stuff is, I think, going to last. But let me start with the good news. This was an absolutely terrible panel. So anything that we got good out of this is really an amazing win given who we were trying to persuade. So the first thing to understand is the anti-gunners in the last several years have developed a new, very dangerous policy and proposal to try to prevent the ability to carry guns, even if you have your concealed carry permit. And keep in mind that while permitless carry is on the march across the country, there are parts of this country where the blue state politicians continue to control and dominate because they control the governor's mansion and the state legislatures. Like a place like New York is a perfect example of this. So one of their new pet theories that they've been advancing is what's known as the restricted places theory, that specifically says that even if you have the right to carry a gun, even if you have a permit to carry a gun, you have to get permission from a proprietor or an owner of a private piece of property or a private business or a private building before you can go onto that property or to go into that building, even if that building is open to the public. Specifically, give you an example, if you're driving down the highway with your gun and a concealed carry permit, you pull off at a local gas station to get gas, and you go in to get some food or something from that little convenience store associated with the gas station, you will not be, under the anti-gun theory here, allowed to carry your gun in there unless you first get permission from the owner of that gas station, or that owner of the gas station puts up a big sign that says guns are allowed. Guns are allowed. You got that right. So I'm happy to report that in a 3-0 decision, the panel said that was unconstitutional and not allowed. This is a very, very big deal. And the reason why this is a big deal is if the anti-gun movement cannot win that argument in front of this panel, which is very favorable to them, it's going to be very difficult for them to roll this out across the country with the court system, because this was a good panel for them to win on, and they lost 3-0 in front of a Biden and Obama and really a law and order conservative type. So if they can't win that argument in the Second Circuit in New York City, it does not bode well for them being able to win that argument anywhere else across the country. And other judges, including the liberal judges, I think will look to the Second Circuit on that point in a favorable way for the Second Amendment community. So that is a big win, a big win, and that is a very large deal. Do not kid yourself. The second thing that's quite interesting is on the licensing thing. Remember, there's two things going on in these cases. The one is licensing specifically whether or not a license can issue, and when can it issue. Now, we know from Bruen and even the concurrence by Justice Kavanaugh and Roberts in the Bruen case, what they're laser focused on is objective standards. Yes, no. Have you ever been convicted of a crime? Yes or no. Have you been convicted of murder? Yes or no. Have you ever been involuntarily committed to a mental health institution? Yes or no. These are objective facts. There's no squishy squish or discretion here. This three-judge panel said, and this is the good news, that there is no requirement and that it violates the Second Amendment to require people to turn over their social media accounts, including anonymous ones, to the government. That is a violation of the Second Amendment, arguably the First Amendment as well. And they said that part of the licensing regimes is not constitutional and is now declared unconstitutional and enjoined in the state of New York. But they also go on to approve a lot of the licensing requirements that Kathy Hochul and the government of New York put into place. I think a lot of this will not stand. Specifically, they came out this panel and said that the good moral character requirement is constitutional and that you are allowed to have some discretion. And this is where they're going to blow themselves up, because if you watch this Four Box of Diner channel, you know what I'm about to say. There is no discretion allowed in licensing regimes. We know that for at least two reasons. One is the Bruen case said these shall issue permitting regimes have to be objective standards. Discretion by its definition is not objective. It allows a government official to exercise discretion in whether or not you have the right to keep and bear arms. It is not constitutional. That is both under Bruen, and here's the other thing, and remember, I connect the dots up for you. During the Rahimi oral argument, we've done videos on this. During the Rahimi oral argument, the Solicitor General of the United States, the top lawyer for the Department of Justice in Merrick Garland, the SG, she specifically pointed out that executive branch officials, which is what all these licensing agencies are, all these state police departments are. These are all executive branch officials. They are not allowed to exercise discretion as to who can carry and who cannot, who can have a gun, who cannot. That is not Mark Smith. That is the U.S. Supreme Court in Bruen, and it's the Joe Biden Solicitor General. So the fact that this three-judge panel out of New York says that discretion in licensing is allowed means A, they did not read Bruen carefully, and B, they did not pay attention to the Rahimi oral argument and the major concession by the anti-gun Solicitor General and the Department of Justice. This will come back and bite them on the butt. So that's why I'm not offended by the fact that they did this. I am offended in one sense, but I don't think it's going to stand for the reasons I've just explained. I think it's a pretty clear-cut mistake by this panel. And again, this also gets into the issues of the other requirements they held. They wanted a cohabit and disclosure requirement. That was upheld as constitutional. And they also said licensing officials can go out and get additional information about an applicant. Again, all this speaks to subjective discretion on the part of a licensing official. This is not going to stand because, again, Bruen and the Solicitor General's office says that is simply not the law or the Constitution. Nevertheless, the panel did allow this to occur, and that's where we are right now. So they upheld all aspects of the new licensing regime in the state of New York except turning over the social media accounts to the government. Again, that is where the decision was by this court on the licensing issue. Now, let's go down. They also did a bunch of specific things with respect to particular types of sensitive places. And again, big picture, these four cases came together to deal with two big ticket items, sensitive places, which are euphemisms for government-mandated gun-free zones, and New York's new licensing regimes. So licensing regime, they upheld the entire licensing regime on the grounds that discretion was permitted and good moral character requirement is allowed. None of this will be true at the end of the day, but they did knock out the social media requirement. You don't have to turn over social media information to the government. So that's where that says on the sensitive places. The first part was this restricted location argument, this restricted restricted carry argument, which I already talked about, where you can't go into gas stations or a restaurant unless you get permission from the owner. That restricted carry law was declared unconstitutional for the basis of preliminary injunction, and thus the preliminary injunction as to not being able to carry guns in those places has continued on. That is enjoined at this point. Now, as to the other aspects that were litigated, the Second Amendment community lost all the other places, quote-unquote sensitive places arguments. They lost specifically on parks and zoos. Now, we're going to talk about how they got it all wrong. Basically, they upheld the law that says you can ban guns in parks and zoos. They upheld the law that says you can ban guns in places that serve alcohol. You can ban guns in theaters, conference centers, and banquet halls. You can also ban guns. Well, they actually said that you can ban guns in the context of exercising gatherings to exercise constitutional rights for protest and assembly. But on that ground, they specifically said the plaintiffs lacked standing. They didn't really get to the constitutional questions. And again, the good news is we did prevail on what's called the no carry default provision. That is a big, big win for us. The biggest thing we had to win, and we did win that. So that's good news. Now, let's break down the mistakes they made on these other sensitive places. The first thing I want to point out, and this is hysterical, major mistake by the panel. They actually rely upon a law that doesn't exist. I kid you not. They rely upon two laws called the Statute of Northampton that have been adopted allegedly by two states at the founding era. One is the state of Virginia, one is the state of North Carolina. Okay? And if you go to, if I can find it here because there's a ton of pages, if you go to footnote, I'm sure you're going to want to do this, folks. If you go to footnote 73 and 74 on page 184 out of page 261, that's page 184, footnotes 73 and 74. That's your homework assignment to check out these footnotes. I'm just kidding. Don't do it. Don't kill yourself. Yes, indeed. In these areas, they talk specifically about a Virginia statute and North Carolina statute embracing the Statute of Northampton. Now, the Statute of Northampton was an Old English statute that was around that literally before the birth of William Shakespeare. It's hundreds and hundreds of years old, and it basically says you cannot carry a gun to the terror of the people, in public places. The anti-gunners try to use the Statute of Northampton and American analogs that embraced this law in the United States and early America to try to say that you had no right to peaceably carry. This is one of their biggest arguments in the Bruin case, and the U.S. Supreme Court rejected it. The U.S. Supreme Court rejected it basically for one major reason, which is, ready for this, that specifically said that this was not a ban on carrying guns peaceably. None of this stuff said you could not carry guns peaceably. What the Statute of Northampton said was that you could not carry guns to the terror of the people, meaning you could not carry. It's like now, you can carry your gun peaceably, but you can't go into the middle of Times Square, you can't go into the middle of the street, you can't go into your backyard and just start shooting it into the sky or doing something to brandish the gun and scare people in a restaurant. That is using your gun for the terror of the people, to scare people, things like that. You're not allowed to do that. That's what the Statute of Northampton said. That's not my interpretation. That's what the U.S. Supreme Court specifically said in Bruin. And keep in mind, the U.S. Supreme Court said that to the extent there's any ambiguity, on the historical analog record, then the presumption is in favor of freedom, because the presumption is the text of the Second Amendment, which, of course, as many of you point out, as you should, shall not be infringed. Shall not be infringed. That is not just a funny slogan. That is actually the most important historical text in American history when it comes to our right to keep and bear arms, because it's actually in the Constitution. The right of the people to keep and bear arms shall not be infringed. Now, that's what the Supreme Court says. If there's any ambiguity about whether or not there's an appropriate historical analog, we assume there is not. Now, the fact that the Second Circuit actually is quoting and relying upon a North Carolina statute that never existed is quite amusing. Unfortunately, they use that to take away rights of New Yorkers, and I suspect someone is going to be pointing this out in the future. Maybe I'll do a whole standalone video about the fact that the Second Circuit actually used a statute that doesn't exist to take away the rights of New Yorkers. Okay, but let's carry on. The other thing, of course, is with the Statute of Northampton, in addition to the fact that it's not applicable because it doesn't say anything about you can't carry guns in public, you can only not carry guns in public to scare people, to the terror of the people. That's what the Supreme Court says. And they're relying upon a North Carolina statute that never existed. Those two things alone really show you that the analysis that the Second Circuit drew from those supposed authorities is all fatally flawed. But based upon a law that doesn't exist out of North Carolina and their misinterpretation of the statute of Northampton as per the Supreme Court, and the fact that they failed to presume in favor of freedom when there's historical ambiguity on the record, they make yet another terrible mistake, and that is they basically say, and this is what the anti-gunners want, and the anti-gunners argue to the Supreme Court in Rahimi, but it's not going to succeed. They say the fact that there is silence at the time of the founding, that there's silence in the relevant historical period about whether or not a law could be enacted, does not necessarily mean that that a modern-day gun control law fails, but that's absolutely not true, because specifically what the Second Circuit said here was, even though the state of New York cannot come up with historical analog laws that are analogous to a lot of these laws, like banning guns in parks or in zoos or in bars or in theaters or conference halls and whatnot, they said that even though there are no analog laws historically, that doesn't really matter, because the fact that they lack that is not sufficient grounds for the modern-day gun control law to fail. That is clearly, flatly inconsistent with the directive of the U.S. Supreme Court in Bruin that says that if there are no laws that speak to the same social problem that are being dealt with today, then that means that the law today is unconstitutional. And this makes a whole lot of sense, because there are not going to be a lot of gun control laws in 1791. And why is that? Think about it. The same people, why would the same people that adopt the Second Amendment, the right of the people to keep and bear arms shall not be infringed, why would the same American people that wrote that into the Constitution, our fundamental important social contract, if you will, why would those same people go out across America and start enacting crazy gun control laws when they think it's a fundamental right? Obviously, there's not going to be a lot of gun control laws at the time of the founding, because the same people that thought the right to keep and bear arms was the fundamental right are the same people that would have been passing these anti-gun laws, and they're not going to do it because they think you have a right to do so. So in this case, silence does speak volumes. Silence does speak volumes in favor of freedom, in favor of our right to keep and bear arms. It's like the dog that doesn't bark in the night. It proves that we win. But here you have the anti-gun panel on the Second Circuit, and that's basically what they were. I don't think they're rabidly anti-gun. I think they're just naturally anti-gun. I think that's the nature of the New York City panel here, and their liberal bias. But you get the point. We don't need to belabor the point. They're a terrible panel. They clearly are. No one would disagree with me on this if you support the Second Amendment. But again, the fact that they came out and says the fact that there's a lack of historical analogs is not a basis to say that these laws are unconstitutional. Clearly shows that they either don't understand the Bruin methodology, or they don't want to understand it, or they want to come up with some excuse to avoid it. And that's why they go on to say, so how exactly do they come out and say that you can ban guns in parks and zoos and places that serve alcohol? And here is where they go awry. They specifically say the reason why they can do so is that there's an American history of banning guns in places that are densely packed with a lot of vulnerable people. Now, this is just made up hooey. Made up hooey. And why do we know that it's made up hooey? To argue that the fact there's a lot of people in a place, it's very populated and it's very vulnerable, blah, blah, blah. Why is that hooey? Well, because the U.S. Supreme Court already addressed the specific point. In Bruin, they specifically said, as you know, that you cannot declare all of Manhattan a gun-free zone or sensitive place just because there's a lot of people around and there's police generally around. That is simply not a basis. They already ruled on this and said it's not permitted. Keep in mind, don't forget that the Boston Massacre back at the time of the founding occurred in one of the most congested parts of America at the time. It was downtown Boston where the Boston Massacre took place, where the British soldiers engaged in a mass shooting, killing 8 patriots. The reason why I bring this up is during the trial of the Boston Massacre, British soldiers, Founding Father John Adams, the lawyer who represented the British soldiers, stood up in court in America and says, we admit and we acknowledge that Americans have the right to bear arms in public. But that doesn't mean you can abuse the privilege and not misbehave. And his defense was that even though the patriots were allowed to have guns in public and carry them peaceably, there was enough basis for the soldiers to fear for their lives and they were allowed to exercise self-defense. But it was conceded by John Adams himself at trial, representing the British officers, that every American had the right to carry guns, even in the most congested part of our country at the time, which was lower Boston, which is where the Boston Massacre took place. So when you have this panel in the 21st century saying that if it's congested area, there's a historical tradition of banning guns, is simply hooey. Now, the other thing they try to say is, well, we have to keep in mind, and this is the language they use, they say something like, oh, well, you know, we have to keep admitting that we don't live in the same world that we once did. Hello! Every moron understands the 21st century is not the 18th century. But guess what? The 18th century Constitution serves us well, and that is the binding document. Just because we live in a different country today does not mean we can say that we're going to have presidential elections every 9 years instead of every 4, or Senate elections every 12 years instead of 6. Or that we can add a 4th branch of government in addition to the 3 branches of government we have. No, the same 18th century Constitution that we govern all aspects of our lives includes the Second Amendment and must be respected as such. That's what the Supreme Court itself has said. This panel doesn't seem to appreciate that. So my last point here I want to say is they made 2 other methodological mistakes. We're going to do a lot more videos on this to really use this as a teaching moment for a lot of people. The first is they said that 1868, which is after the 14th Amendment, is just as probative of 1791. This is clearly methodologically wrong. I find it interesting that the Second Circuit decided not to quote the one person that's done the definitive work on that, and that is Mark Smith in the Harvard Journal of Law and Public Policy. They conveniently skipped over that scholarship. I wonder why. We know why. They're dodging the metaphorical bullet on the point, but trust me, the Supreme Court is aware, and the Supreme Court will not miss the points that I make in my article, even though the Second Circuit conveniently did. But beyond that, the other critical thing is they never come to grasp with what makes something a sensitive place. And we're going to do a whole video on this, so I'll make this quick. If you look at the 3 places that the U.S. Supreme Court has said are sensitive places where you can ban guns as the government, there's 3 of them. There's 3 of them. Bruin said them. That's a legislative assembly like the Congress, Capitol Hill, courthouses, and polling places. If you go back to the founding era, you will find the one thing those 3 things have in common is they all had comprehensive armed security providing protection for the people there. Legislative assemblies had sergeant of arms protecting the people that went to those legislative assemblies. Courthouses had bailiffs that protected court proceedings, and the polling places were run by sheriffs and sheriff deputies and the like. So if you look back at the founding, the one thing those 3 sensitive places have in common is a form of comprehensive security. You can't simply say no guns are allowed at a park and a zoo or anywhere like that without, of course, providing comprehensive security. And none of these places provide comprehensive security of what we see, let's say, when you go through the TSA line to board an airplane. So again, we'll do more on that later. And the last point, I just think this is kind of ironic and amusing in a sense, is that one of the most famous taverns in American history where the Revolution was contemplated and thought about was Francis Tavern. Francis Tavern in Lower Manhattan, literally about a block or 2 from the Second Circuit of a Court of Appeals courthouse. I know that area quite well. I've been down there quite a bit, as you can imagine. And they're literally, Francis Tavern is literally a few blocks away from the federal courthouse downtown. And of course, the idea that you can ban guns in a place where alcohol is served is simply absurd. The best historical evidence in favor of the anti-gunners might be that you're not allowed to be drunk with a gun, but there is no basis to say that at the time of the founding, you could not go into a place where people were drinking alcohol with your gun. That means, for all intents and purposes, for those people familiar with New York City, you can't go into a Greek diner with your gun because they technically can serve alcohol, most of them, because they have liquor licenses, which is simply absurd, especially if you're not drinking. Nevertheless, that is what this court held. I don't think it's ultimately going to stand. As to what happens next, I think it's going to go back to the lower court and continue to litigate until a final judgment. I suspect someone may seek a cert from the U.S. Supreme Court. I think it might be a stretch to get there. Maybe the Supreme Court would take an appeal from this right now. Hard to say, but I think they might want to wait for a final judgment. So if I were involved with these cases, and I'm not, but if I were, I might want to focus on trying to get a final judgment ASAP. But again, differing minds can have different views as to proper strategy. And again, I'm sure the lawyers are all excellent here and will make good choices as they have so far. Anyway, overall, Pretty much a good day given this panel. Not a great day because we lost a lot of stuff, but we lost a lot of stuff on silly grounds that I don't think will stand the test of time. So overall, this is a good day in the grand scheme of things, even though, yeah, it's unfortunate for our brothers and sisters in New York to have to deal with this unconstitutional nonsense, but this is the system we have, and this is where we are in the country today. So, all right, folks, hope you learned a little bit something here today. Don't forget to like and subscribe here, and don't forget to follow me on X at 4boxes and we'll see you again soon here at the 4boxes Diner.
Orders up. Table 2A.